AAC R4281101C requires every licensee to expeditiously perform all duties and obligations arising from a real estate transaction. This means that brokers and agents must act promptly, efficiently, and with diligence in all stages of representation. Timely performance ensures that clients' interests are protected, transactions proceed smoothly, and unnecessary delays are avoided. Under AAC R428-802A, licensees are required to promptly deliver executed documents to all appropriate parties. This includes purchase contracts, counteroffers, listing agreements, and any signed addenda. Timely delivery ensures that all parties are informed and that contractual obligations become binding once executed. Failing to deliver signed documents can jeopardize a client's position and create potential liability for the licensee. AAC R428-802B establishes the requirement for presentation of offers and counteroffers. A licensee must present every written offer or counteroffer to the client promptly, unless otherwise instructed in writing by the client. This rule reinforces the fiduciary obligation of obedience, ensuring that clients, not agents, decide whether to accept, reject, or counter an offer. The licensee's role is to facilitate communication, not to filter or influence offers without direction. AAC R428-1101D covers licensee controversy and mandates that disputes between licensees, such as commission disagreements or ethical conflicts, must be resolved professionally and outside of the ADRE's regulatory role. The department's purpose is consumer protection, not mediation of private contractual issues. Licensees should handle such matters through negotiation, arbitration, or civil court if necessary, maintaining professionalism throughout the process. AAC R428-1101E outlines the rules surrounding conflicts of interest, ensuring transparency whenever a licensee's personal or financial interests might interfere with their clients. These conflicts must be disclosed in writing to all parties prior to or during a transaction, and in some cases, may require client consent to proceed. Under AAC R428-1101E1, when a licensee is acting as a principal, for example, buying or selling property for themselves, they must disclose their license status and relationship to the transaction in writing before entering into any contract. This prevents deception and allows other parties to make informed decisions. AAC R428-1101E2 extends this requirement to situations where the designated broker or the immediate family of a licensee is involved in a transaction. Immediate family is defined in AAC R428-101 as including spouses, parents, children, siblings, grandparents, and similar close relatives. Because these relationships can create the perception of bias or self-interest, disclosure protects the integrity of the transaction. Under AAC R428-1101E3, a licensee must also disclose if the employing broker or the owner of the brokerage entity is a party to the transaction. This ensures that all parties are aware of any ownership or employment relationships that might influence the licensee's actions or advice. AAC R428-1101E4 requires disclosure of any financial interest held by the licensee, their immediate family, or their employing broker in the property or transaction, other than standard compensation for representation. This includes partnerships, investments, or any indirect benefit that might create a conflict of loyalty. Affiliated business arrangements and joint ventures are examples of potential conflicts under this rule. If a brokerage has an ownership interest in a title, escrow, or mortgage company, this must be disclosed in writing before the client is referred to that entity. This ensures compliance with the Real Estate Settlement Procedures Act, RESPA, which prohibits undisclosed referral fees and kickbacks. Finally, ARS Paragraph 20, MUP 1585, prohibits real estate licensees from receiving any payment fee, or rebate from a title or escrow company for referring clients. Any compensation or incentive tied to referrals is unlawful unless it is clearly disclosed and complies with state and federal law. The rule protects consumers from hidden costs and ensures that referrals are made based on quality of service, not personal gain.